we on? Are we transmitting? We are? Anyone out there? This is Canada, Radio Free Canada calling.
All right, I want to take a quick look at the kind of laws our governments have been slipping through the legislatures over the last 2 years. Some very interesting little laws and rules of practice in our courts that seem to have nothing to do with health. Maybe that's just a coincidence. Maybe it's just a coincidence that while civil liberties are suspended or restricted for a health emergency, we have all these completely unrelated laws getting slipped through, as I say, slipped through the legislatures, parliaments, congresses, whatever you want to call it, whatever you want to call the legislative bodies in your country. They're being slipped through with very little debate, little or no media coverage. It's like they're all just housekeeping.
One would, of course, assume that while civil liberties are suspended or restricted, lawmakers would not try to slip through laws that will completely transform society. No, there's no way that they would do that. They would not try to slip through legislation with no debate, no media coverage that would completely transform society during a suspension of civil liberties. For example, why would you do that? While in Canada, if you are a dissident, you can't even leave the country because of various mandates. You are a prisoner here. And of course, there was the declaration of emergency powers here. That happened in Ottawa. It was the now you see it, now you don't emergency of Mr. Trudeau. But you'd think while fighting a war, I guess it's a war, a health emergency war, government would be too busy to completely transform Western society. The governments in the West, in the Western world, would be too busy to transform the West. Well, you'd be wrong. Governments have been very busy tinkering with our laws and our rights on completely unrelated matters. It's not like they're building hospitals or conscripting nurses or redesigning elder care. They haven't done any of that, but they have been busy on some completely unrelated matters. I will give you some examples. But I'll tell you, the examples that I'm giving you are particular to British Columbia, Canada, but I suspect this is going on everywhere in the West. You'll have to tell me what you think, or if you see similar things in your jurisdictions. So, for example, in British Columbia, ostensibly on the basis of health concerns, jury trials in civil matters have been suspended. You can't go in front of a jury of your peers, go in front of a bunch of people who aren't paid by the government, and pitch your case and hopefully get a good result. You cannot do that. I suspect this banning is permanent. It's also, for one thing, it's a lot cheaper not to have to impanel a jury. It takes longer. There's technical difficulties, administrative costs, and the like. It's much cheaper just to use the paid judges you already have on the payroll. Here's another example. Oh, I should say before I go on, the suspension of civil juries does not affect criminal matters because that's in the Constitution, and in Canada you would have to amend the Constitution, and that would probably get more publicity. All right. The other thing that's happened in British Columbia is the right to sue for personal injuries. That's pain and suffering, income losses, future income losses, cost of future care. All that has been banned, has been suspended in the case of motor vehicle accidents. There's very little discussion about this. They just did it. And I'll do another video on the steps they took, which were kind of creepy as well. But the end result is you cannot sue if you're rendered a quadriplegic by a drunk driver. You cannot sue that driver and get access to his insurance money. You'll just have to rely on the government now. That's a big deal. Yeah, this is called Nofault. Nofault. It's a no-fault regime. Sounds nice. No fault. Your premiums are going to be lower. Wow, that settles it, doesn't it? But it is actually a really big deal. You aren't going to be able to ask a judge or jury to treat you as an individual with individual losses. You aren't going to be able to say an injury to you has affected you personally in a unique way. No, now you're going to be in the hands of a government tribunal that will tell you what treatment you can have and what benefits you are entitled to under a chart or policy. And you are a number. That is a big deal, a big loss. All right, the next example of these rules, laws, practices that have been slipped in is out of the blue in British Columbia. In the middle of a pandemic, we lawyers learned that henceforth, when introducing ourselves at the beginning of a court proceeding, we must declare our personal pronouns. So this is at the start of every judicial proceeding. I have to say, my lord. I used to say my lord. I'll get to that. My lord, my name is Mr. Sidney Smith. He, him. So now I think you see what is going on. In the first case, a jury of your peers is replaced with a government-appointed, trained, and paid judge. In the second example, your right to sue, that's replaced with a government-controlled institution that will manage you and your rights and benefits. Now, the pronoun example, that's a rule of practice, but it's a law, subject to the judge waiving it or not mentioning it or something like that. This clearly reflects a political ideology, really one that emerged around the time of the French Revolution, one of radical egalitarianism, radical subjectivism, and the complete absence of limitations on what an individual can do. An individual can declare himself to be something. That's reflected in that request. The next change also comes out of the blue, and it requires a little bit of background. In the English system, we have called judges lords and ladies since time immemorial, since the first Norman courts. We call them lords and ladies. It's a status. It's about hierarchy, it's about tradition, also about independence. A lord or a lady, despite being paid by the government, has a status that has the aura of independence. One is meant to feel that this person who has that status can act independently of the government. So this is an example, the use of this archaic language, of language that has content, that's connected to the past, that's connected to the tradition. It ties us to the tradition of independence of the court. Just got scrapped. Now, why would they do that? For now on, out of the blue, no discussion, we will call lords and ladies, we will call them Mr. Justice and Mrs. Justice. Now, you may say, well, that sounds great. That's fine. In fact, the Supreme Court of Canada has been doing that for years. But what I say is, it's an example of targeting tradition, targeting hierarchy, and replacing it with names that are almost administrative sounding, almost clerical sounding. These are officers of the state, not aristocrats. It represents a break with tradition. That's important. You may say, well, it's just words. Words matter. The governing mythology you live under matters. The language you use to describe people matters. And again, I'll suggest that this represents the substitution of an ancient hierarchical system with one in which state control is predominant. These are state officers, and that's reflected in this language, Mr. Justice, Mrs. Justice. Although I have to say, when I use that language, when I hear that language, it does sound to me a lot like, Mr. Tickle or Mr. Meanie or something from that kids' book series, I guess I'll have to get used to it. We all will. These are the changes we're dealing with. These are not little changes, they're big changes. There is so much of this utopian stuff going on, it is actually really hard to keep up. And I'll try to get you more examples when I can. But in my view, this is dangerous. It's dangerous because it does have the effect of transforming society. It is utopian and socially transformative in little drips. Drip, drip, drip. It will affect your life and the life of your kids when you transform a society. So oppose it in any way you can. At the very least, be aware that this is going on. Now, what I want to do now is take a look at a bill working its way through the Ontario legislature. In Ontario, it passed first reading, I think in December, with the Conservative government's support. It's a private member's bill. Okay, so here it is. You should see it on your screen here. It's a bill of the Legislative Assembly of Ontario. Bill C-67, an act to amend various acts with respect to racial equity. It's a private member's bill, first reading December 2nd, 2021. Now, I don't want to, and I don't think I need to get too much into the politics. Critical race theory is what this is. You can read about it. I want to get into more of the language. And this is a common theme that I'll be looking at, which is how legislatures are using language to make laws increasingly unclear, increasingly indeterminate, which is the exact opposite of what laws should be. In a free society, in quotes, free society. This bill is dangerous on its language alone. So you can look at the politics, think about it, decide what you believe and what you don't, but I want to just show you the language in here. The kind of weaselly, indeterminate language that will have you, if you're affected by it, if you're affected by laws like this, always on your toes and never sure what your rights are. Now, my first exposure to critical theory was a long time ago. Something called critical legal studies. That's the first time I heard anything about this type of ideology. Critical legal studies is a school of critical theory that developed in the United States during the 1970s. CLS adherents claim that laws are devised to maintain the status quo of society and thereby codify its biases against marginalized groups. Despite wide variation in the opinions of critical legal scholars around the world, there's a general consensus regarding key goals of CLS, this critical legal studies, to demonstrate the ambiguity and possible preferential outcomes of supposedly impartial and rigid legal doctrines, and to demystify these apparent social constructs and all that. This was considered the first legal theory and legal scholarship in the United States to have espoused a committed left political stance. Okay. During its peak period, that would have been, I think, in the 70s and 80s. Its proponents included guys like Roberto Unger. You can look him up. People like Unger sought to rebuild institutions along Marxist lines, basically. Critical legal studies had its intellectual origins in the American legal realist movement. In the 1930s, prior to the 1930s, American jurisprudence had been dominated by formalist accounts of how courts decide cases, and accounts which held that judges decide cases on the basis of rules, legal rules. And these guys said, nah, they decide cases based on what result they want. And in fact, there's a lot to that, and I've done a video on that. And a legal realist judge will decide what he wants and argue backwards. So, okay, this is the outcome. How do I get there? And reason backwards, which is exactly the opposite of the way it's supposed to work. In fact, that's clearly what's happening, at least when things become political. Now, critical legal studies, when I first encountered it, was just It was mainly about class struggle. It really hadn't evolved into the newer branches. That laws basically protected the rich, the elites, the bourgeoisie, capitalists against the proletariat, workers, and other marginalized groups. Now, critical legal studies, its prominence has waned. However, offshoots of CLS, critical legal studies, have included critical race theory. And here we go. Let's have a look at some of the language in here. First, there's an explanatory note, very helpful. What does it say? Various acts are being amended. Okay, that's great. Let's look at this bit here. A number of amendments are made to the Education Act. New subsection 10.1, subsection 3 of the Act is amended to require the minister to direct a board to develop its anti-racism accountability report if, in the opinion of the minister, there is indication that the board's new teacher induction program does not include anti-racism and racial equity training. Stop. Here's our first Weasley word, indication. What is an indication? Well, just think of medicine. If there's an indication for something like an x-ray, we're not even at the point of a diagnosis. This is just like, well, okay, there's something here that might be something. Now that's a really low standard. Of course, we're going to have to figure out later what anti-racism means. It needs to be defined. What does racial equity mean? These things need to be defined for this to have any meaning, but this is the first thing to watch out for. Words that set a very low standard for the minister to get involved. Okay? Now look down here. Fines. New subsection blah 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 provides for fines for persons who disrupt or attempt to disrupt proceedings of a school or class through the use of racist language or activity. Racist language. What is racist language? And what activities? Now here's something interesting. Look at the second paragraph here. Again, this is just in the explanatory note. There's amendments to the Higher Education Quality Council of Ontario Act, lovely name, which provide that at least one member of the council shall be a person who has expertise in racial equity. What is expertise in racial equity? In the post-education sector, and that all members must have a proven commitment to racial equity. You have to be committed to the cause that is being advocated here. And it doesn't have to be this. It could be anything. This is extremely intrusive. You're going to have to show that you are a committed member of the party. Let's see if we can find some definitions. Anti-racism, here, under the Education Act, the amendment, anti-racism is defined. It means the policy of opposing racism, including blah, blah, blah. Those subjected to this kind of law are going to be in a position of having to advocate, having to take positive action. And I'm sure we would hear why that's really important, but that's very intrusive. Okay? Now, how's racism defined? Means the use of socially constructed ideas. Now, right there. So this law clearly is committed to a particular vision of society, but it gets better. Racism means the use of socially constructed ideas of race to justify or support, whether consciously or subconsciously, the notion that one race is superior to another. So one can run afoul of this based on a subconscious state. So you may have absolutely no intention of offending anyone and not have any conscious views along these lines, but someone, based on an indication, may identify you as having subconscious, sublimated ideas that run afoul of this. Again, we're entering a world of an Alice in Wonderland world. All right, just a few more examples. Anti-racism competency. Section 277.28.1, despite anything in a regulation made under this Act, a performance appraisal of a teacher shall include competencies related to a teacher's anti-racism awareness and the teacher's efforts to promote racial equity. So again, the teacher must have commitment, must promote, must advocate. Let's look at amendments to the Higher Education Quality Council of Ontario Act. Commitment to racial equity. If the minister learns, upon conducting an investigation or otherwise, that a member of the council does not have a proven commitment to racial equity in the post-secondary education sector, the minister shall require that member to take anti-racism training within the following 6 months. So again, silence will not betoken consent, to quote Thomas More. It is not sufficient to do no harm. One must be a committed advocate. You must wear the appropriate colored shirt, and you must do it when you're told to. There's very little room here for anything approaching freedom of conscience and freedom of thought. So these are some examples of the laws that have been slipped in, the rules of practice that have been slipped in during the suspension of civil liberties. I expect more. The law we just looked at, Bill 67, effectively ends political debate. A contrary idea expressed in language is now against the law, presumably, if you fall within the parameters of this legislation. One can expect similar legislation to begin to encompass other professions, and perhaps all citizens at some point. Some interesting features of these new types of laws: subjectivity, subconscious intent in terms of an offense, harm, which is subjective. And there's also an irony, I suppose, in that, as I noted earlier, critical legal studies criticize laws as indeterminate and favoring the wealthy and the powerful. Well, now that the left is firmly in power, evidently, it continues to use laws and the pretense of their objectivity. I mean, who could be against the cause of justice? And yet, the law isn't likely to solve any problems. It's very likely to create conflict. It's very likely to create anxiety and fear and a kind of reign of terror in which you can never know your rights. And to the extent you can feel safe, it is because you are a party member, committed advocate and promoter of the regime, and a persecutor of its enemies. That's it for now. I think that's plenty.